So I went to Kuwait for 7 months and COVID hit right after I got back.
What's the difference between a will and a trust?
My son bought a car, but we wanted to keep it in my name so that I'm the one that gets the parking tickets, for example. And that really happened. We don't have probate tax. Doesn't exist in Alberta. We believe in freedom. Rules about how you own real estate and how real estate is registered, that changes from province to province. Although anything related to property, including what happens to your property when you die. My kids didn't help me. I'm on my deathbed and they've just left me for dead and are just licking their chops waiting for my money. Well, guess what? They're not getting any of it.
What if you don't have any relatives? You don't make a will. Like, does your estate, does everything you own go to the government? Like, what happens? Let's say somebody passes away and they had a lot of money and X comes, kind of trying to claim something. You're saying that they don't really have, the ability to do that? What is the difference between being an executor and being a beneficiary to the will? Because there is a difference.
So our phone number is 780.
So welcome, everybody. I hope you are tuned in. You're sitting with your loved one. This conversation is going to be very impactful to most of you who watch me and get the different tips and tricks I talk about finances. And although we're not necessarily speaking about finances directly, I think this is an area where a lot of us have questions. Thank you for joining me on my podcast. I would love for you to share first how you got into the industry you're in now. Tell me a little bit about who you are and what you do.
Okay, well, thanks for having me, Irene. I'm happy to join you, and I hope your clients can get some value out of this.
And maybe I'll start off something very simple with a question, if that's okay. Very simple question. I've come across people who ask about trusts and wills. And to be honest, I've never been able to kind of answer that question. What would you say, kind of being in the industry you're in, what would you say is the difference? If you could explain it in layman's terms, what's the difference between a will and a trust? And why have either one?
It's kind of a loaded question. Not that you intended to load it, but because there's not necessarily a difference. A will sets up a testamentary trust. So a trust, what a trust is essentially when property is held, like the legal title of property is held by a person who doesn't own the beneficial right to that property. So they hold the legal title in trust for someone who actually has the right to enjoy that property.
Hey.
So this happens all the time. For example, like let's say, I have 5 kids. Let's say my son bought a car, but we wanted to keep it in my name for, I don't know, so that I'm the one that gets the parking tickets, for example. And that really happens. Anyways, if my son paid for the car, it's his car, but it's in my name. That doesn't mean I own the car. It means I own the legal title to the car, but at law, he owns the beneficial right to that car. It's his car, but it's in my name. So whenever you get that kind of disconnect between whose property it really is and whose property or whose name the property is owned by, that creates a trust. Now, but you weren't really asking about, please define for me what a trust is. I know what you were asking. You were asking, okay, when they do estate planning, one of these things that I read about on the internet and stuff is, should I be setting up a trust? And the answer is in Alberta, it's almost, it's not very common that we do that. And so the reason that people set up trusts as part of their estate planning, from what I understand, is because places in like British Columbia and Ontario love taxing people and taxing them a lot. And they have a really high probate tax. And so one way to avoid that probate tax legally is to establish a trust and put the property in that trust. That's as far as I understand it. Like I said, we don't really do that in Alberta because we don't have probate tax. Doesn't exist in Alberta. We believe in freedom. So we have a small, you have to pay something when you apply, if you have to get a grant of probate or a grant of administration, which is basically when the court is saying the person, we confirm that this person is authorized to administer the estate, whether it's by a will or if there's no will. That's the difference between a grant of probate, if there's a will, grant of administration, there's no will. So there's a fee associated with that application, but it's like a few $100s.
Right.
There's no tax benefit. I shouldn't say there's no tax benefit. I'm not a tax lawyer. I'm not an accountant, but you don't have the same kind of benefit by setting up a trust here in Alberta that you would in British Columbia and Ontario or other places where they have a probate tax. So that's my understanding. I as a estate planning lawyer have never set up a trust for a client. It doesn't mean that some people might still do that here in Alberta, but it's kind of a niche service, and I'm not really familiar with all of the ins and outs as to why you do that. And that might be more of like a tax. There might be other reasons you'd want to set up a trust besides just avoiding the probate tax, but it's not something we commonly do here in Alberta.
Gotcha. Okay. So when I asked the question, it was probably it sounds like based on how you describe what a trust is, it almost sounds like it's an unrelated question. Am I safe to assume that kind of?
I don't think it's unrelated. I think people do searches on the internet about estate planning and how to avoid taxes, and they get articles from British Columbia and Ontario
Gotcha.
that say you need to set up a trust. And then so they're like, well, this is what I got to do. And so then they think they do it because maybe they think, well, tax is federal and there are federal taxes, but property is governed at the provincial level generally. So anything about property changes from province to province. So insurance, that's property, changes from province to province. Rules about how you own real estate and how real estate is registered, that changes from province to province. Although anything related to property, including what happens to your property when you die, the rules and everything change from province to province.
Gotcha. Okay. So for sakes of being very simple here, since we're both from Alberta, let's talk about kind of like just in the realm of Alberta. So when someone dies, what happens to their property, for instance, if they're married and they both own the home? Does it naturally just slide into the surviving spouse's name? Is that how it works?
That's a very specific question. So let me kind of rephrase the question for you a little bit, because there's kind of two categories. There's I have a will and I die. I don't have a will and I die. Okay. So if you have a will and you die, your property gets administered according to your instructions in the will, as long as your will deals with everything. That's one of the biggest reasons why you need to get a lawyer to do a will, is because you might not actually, like anybody can write a will. You just write it in your own handwriting, date it, sign it. That's a will. But just because you can technically create a will doesn't mean you're doing everything you want to accomplish. Words matter. So anyways, so one of the big reasons you would get a lawyer to help you with the will is just to make sure everything is going to happen the way you want it to. And so that's what happens if you die with a will. It goes where you said you wanted it to go. With one exception, there's some property that never forms part of your estate and that passes outside the will. You mentioned one of them. If you're joint tenants on real estate, so on your title, if it says as joint tenants, those are magical words. If it says that, then when the first person dies, immediately upon their death, the property automatically transfers to the people left on title. If it's one person, it just transfers to that person immediately. Title doesn't change. You have to submit paperwork to change your title. But as far as the law goes, as soon as they die, they immediately no longer own that property. That's what joint tenancy means. So if you're a married couple, you're both on title, you own it as joint tenants, right? That just makes it a lot easier. You don't have to do anything. Your husband dies, you own the property. You don't have to, besides updating the title with the, one little piece of paper that costs like $5 to register, you don't even have to do that. But if you go to like refinance, you will have to do that.
Right.
So that's joint tenancy. That passes outside the will. The other things that pass outside the will are things with a beneficiary designation. If you've got a beneficiary named in your TFSA or your RRSP, those never form part of the will. They pass outside the will. If you have life insurance and you've got a beneficiary, that passes outside the will right to the beneficiary. And all the tax savings you get from passing money through life insurance. Life insurance is never taxed. It's one of the strongest lobbies we have in Canada, and they have successfully helped us avoid taxes. You can really leverage life insurance products to avoid taxes. Everything else will go according to as you say it in your will. If you die without a will, it's the same situation, except the law has set rules. And so, am I able to share my screen? Yes, I can. Okay.
Yeah, perfect.
So I'm just going to share. I don't know the answer, to be honest, screen, because so I'm going to look it up.
Okay.
You can see this Canley screen right here. Okay. So this is a free database anyone can go to. So I'm just in the Consolidated Statutes of Alberta, and I'm going to go to the Wills and Successions Act. I think that's the right one. There's two different acts that deal with this type of thing. There you go. I did choose the right one. Distribution of intestate estates.
Okay.
Intestate means you died without a will. Okay, so here's all the rules. Let me make it bigger. Oh, now I lost. Okay, here we go. So if there is a spouse or adult interdependent partner, but no descendants, everything goes to the spouse. or adult interdependent partner. Adult interdependent partner, we don't have time to go into that. That's that comes from the Adult Interdependent Relationships Act, and it's there's a thing, like you become that. That's a question that you can answer, but you have to go look at that other law. Anyway, so it goes to a spouse or adult interdependent partner. No kids, it goes all to them. If there are kids, so if they leave a spouse or adult interdependent partner and one or more descendants, then if all of the descendants are also the descendants of the spouse or partner, it all goes to the spouse or partner.
Ooh, okay.
So in other words, Irene, if you and I had a couple kids and I died, and even if we weren't married and I didn't have a will, you would get everything. It wouldn't go to the kids. It would go to you, which makes sense because you're their mom.
Right.
But sometimes you have blended families, right? And so this next one is for blended families. If any of the descendants are not the descendants of the surviving spouse or partner, then the surviving spouse or partner is entitled to the greater of the prescribed amount, which I'm not going to look it up, but it's somewhere around $150,000 to the regulations, or 50%. So whichever is greater, half of the estate or $150,000, whatever is greater. They get the first $150,000 or first 50% of the estate. And then the rest goes to the kids. And then if there's no kids and if there's no partner, it goes to the kids. If there's no kids and no partner, then it goes to siblings. If there's no siblings, then it goes to parents. If there's no parents, then it goes to aunts and uncles and so forth. Like it gets complicated, but for the most part, people have a surviving spouse or surviving children.
So that's why you want a will, right? Because it's all assuming it's intestate.
That's right. This is the intestate rules. Yeah, that's why you want a will, because maybe you don't like your kids.
So you can do that in a will.
Yeah, you don't have to leave it to your kids. You can leave it to whoever you want. You could say, I don't like any of my relatives. They're all jerks to me. My kids didn't help me, and I'm on my deathbed, and they've just left me for dead and are just licking their chops waiting for my money. Well, guess what? They're not getting any of it. Unfortunately, it's sad to say that happens. Or there's one kid that really steps up and the rest don't want anything to do with it. And so, you're free to leave it to whoever you want and to not be fair about it. The only exception is if you have a spouse or kids that are dependent on you, they can bring a claim against your estate if you didn't provide adequately for them. So.
Okay. So that's a different conversation.
It's a different conversation.
Okay, gotcha.
You're essentially free to do whatever you want with your money, unless there's people depending on you. Then you got to provide for them, and if you don't, they will still be able to bring a claim against your estate to get what you should have provided for them.
Gotcha. So then, just for fun, what if you don't have any no relatives? You don't make a will. Like, does your estate, does everything you own go to the government? Like, what happens when you have nobody? Like, let's say there's nobody to claim this.
That's a good question. I'm looking the act back up because it is like it's so rare. I've never come across it.
Okay.
Hold on. First stirpes distribution to descendants. Okay, share again. Children, deceased children, we already said that. So if there's deceased children that left descendants, they get it.
Mm.
Then you go so that's the per stirpes distributes to descendants. If there's no descendants, there's no kids or deceased children who had children, then we go to parentelic distribution. So now we go up. So first we try to go down. If we can't go down, then we go up. So if there's no spouse, or partner, or descendants, then goes to the parents in equal shares, or the survivor of one of them. If there's no parents, then it goes to the descendants of the parents. So your siblings, half siblings.
Right.
If there's no surviving parent or descendant of a parent, but there's grandparents or descendants of grandparents. So now we're talking about grandparents or aunts and uncles, but descendants of the grandparents, not by marriage. Then you go grandparents on each side get half. If there's no surviving parent, descendant of a parent, grandparent or descendant of a grandparent, but there's one or more great grandparents or descendants of great grandparents, then it goes to them.
So basically, if you're saying it goes down, then it goes up, then it goes like up and to the side, I guess, if you will.
Yeah.
So who takes care? Maybe we're getting too much into it, but this just came up. Who takes care of finding these ancestors, if you will? You know what I mean? Like if there's no one,
I don't know.
Will.
I don't know. Some good Samaritan. If there's a lot of money there, then someone will do it, usually. Okay, so if there's no heirs, that's what you asked. Here's the answer.
Yeah.
It goes, the Unclaimed Personal Property Invested Property Act applies. So I don't know what that act says, but presumably, I think the government probably would take it.
Gotcha. Okay, so I think the main theme here, guys, is actually having a will. So you have a will. I've done a will in my first marriage, did another will in my second one, and now that I'm separated, would you say in something like that this kind of life event, I should be relooking at my will and redoing it.
Yeah, you're gonna make me go back to look at the act again, because basically when you become separated, then the law says that the as far as distributing your estate goes, it pretends that they died before you. You're the estranged spouse, so they're out of the will.
Right.
Unless you do a new will because you really like them, even though you're separated, and you really want to leave them something that theoretically could happen, then you would have to do a new will to make sure they get something. Otherwise, they don't get anything.
Oh, really?
They're out. Yeah.
And so when you hear stories, and I don't know if this is just Hollywood, when you hear stories where there was a will and an ex will try to kind of come, let's say somebody passes away and they had a lot of money and ex comes, kind of trying to claim something, you saying that they don't really have, the ability to do that? Or is there like that's a very deep question.
Okay, separated spouse deemed predeceased. So the surviving spouse of an intestate is deemed to have predeceased the intestate. It's intestate and a surviving spouse. So this is only if there's no will.
Gotcha.
If there's no will, then they're deemed to have been separated. If they've been, or predeceased them, if they've been living separate and apart for more than 2 years when you die. So if they haven't been separated for 2 years, then it doesn't apply. Or there's a declaration of irreconcilability under the Family Law Act, or there's a separation agreement.
Gotcha. But you said that was based on dying intestate?
Yeah, but that's right. That's intestate. So if they're in the will, I don't think I think they would still be included in the will and would still get something.
Right. Okay.
So if you're separated and right now you have mirror image wills, right, where everything goes to your spouse, then you should probably get a new one.
Yeah. Okay. Kind of in your experience, would you say most people don't have wills or do have wills?
I don't know the question. All of my estate planning clients have wills.
Okay. Okay. I guess maybe age group then that would probably take me to a different conversation. Like in age group wise, like would you say a lot of your clients they should have had a will sooner, kind of based on where they are in life? Or I know that better late than never, but do you know what I'm trying to ask? Like, are a lot of your clients who just decide they want a will because, hey, somebody passed away, so they thought they should have a will, or people proactive and know the value of a will?
Oh, yeah, I don't know. Like some people, obviously, a lot of my clients or some of my clients are proactive, right? That's why they're reaching out to me to do a will. And sometimes it's because they just had to act as the executor for their mom or dad's estate. And they're like, oh my gosh, I need to do this. But no, I think a lot of people, like my will's probably out of date. I did it back 9 years ago. Something like that. My first summer as a summer student, the lawyer that I was working with did it for me and my wife. And so I probably need to update mine. Like it's just human nature, right? We don't actually think we're ever going to die.
Right.
And so we don't worry too much about it. And it's a kind of thing where, we try to draft them as well so that it's like you just have to do it once and then you're done. But we always tell people, look at it about once a year, pull it out, dust it off and look at it and make sure that it still is accomplishing what you want to accomplish. And when you have big life changes, like you get separated or you get divorced or you have a kid or you move somewhere or you get rid of a bunch of property, then that might be time to look at things. And as we get older too, the people we know in the world, like it starts shifting, right? Like when we're young, everyone we know, a lot of people we know is older than us. And then as you get older, it's like those people start dying. Like you want an executor that's younger than you, right? You want an executor that's going to outlive you. Right. And so, as you get older, you may have to change who the executor is because they die or they no longer are able or you're no longer close to them, whatever, any number of reasons. And when your kids are little, obviously you want them to get all of your estate. But as they get older, if they turn out to be jerks, which heaven forbid, but it happens unfortunately all the time, then you'll probably want to change your will there too.
Right. So, I guess that brings me to my next question. When you choose an executor for your estate, you want somebody who's likely younger so that, you're going to predecease them. What other considerations would you advise someone to kind of think about when they're choosing an executor?
This is an excellent question. I think a lot of people have this question. They're not sure who they should appoint. And first of all, I don't know who you should appoint. But what I do know is that it's no great honor to be named executor. And sometimes people feel like they're bestowing an honor on somebody. You're not bestowing an honor. You are like it's kind of a cheap move, because it's like on your deathbed, you're like throwing this responsibility on them, and they're going to feel obligated to do it because, you got to honor a dead person's wish. That's something that we feel culturally pretty strong about. So first of all, it's no great honor that you're doing somebody. Like, so a lot of times people be like, oh, I think I want to leave all of my kids as the executors because I don't want to favor one or the other. You're not showing preference by choosing one over the other. You're like, that's the one that who you should choose should be somebody who's responsible and going to get it done. You don't want someone to have to try and deal with a committee to administer the estate, right? So more than one person, you can do more than one person. People do that all the time. But I always just, advise caution of like, listen, like let this person get it done. Like get out of their way and let them get the thing done. Pick someone that you trust and one person and assign them. And then have alternates, one or two alternates in case they're unable or unwilling to do it or to continue to do it. Have some backups that can step in. But sometimes it's tough. Sometimes people have a hard time even thinking of one person, especially if they're quite old. They're getting up age in their 80s or 90s. It can be tough. Like I've had clients where they're like, I don't know. I actually don't know who to name. And, I can't solve that problem. There are like there are professionals who will act as executors. They're quite expensive.
Oh.
Yeah.
$50,000
type of thing to act as an executor is somewhere around the going rate if you're going to have a professional. So, anyways.
Gotcha.
In other words, I don't know who you should name, but try to pick someone that you trust and that is organized and gets things done.
But it's interesting. Yeah, no, it's interesting how you said it's not an honor. Yeah, I think I've seen that even when I was working at the bank. It was such a task for them. A lot of them, most of them, if not all of them, didn't really know what they were doing. Then you get into the point of estate taxes and how, anyways, there were a lot of horror stories. So when we think about, so maybe we can clear this up for a lot of my viewers too. I know the answer, but I want them to know the answer as well. What is the difference between being an executor and being a beneficiary to the will? Because there is a difference.
Mm-hmm. Yeah. The executor is the person who is going to be your personal representative for the purpose of carrying out your instructions in the will. Or if there's no will, for doing what the law says they have to do as far as making sure everyone gets their piece of the pie. They are responsible. They are liable personally to make sure that they maximize the estate so they don't have to waste money and things like that. It's not like they have to pick the right investment, but if there's a bunch of money and it's going to be sitting around for a while, then it should be somewhere like a GIC, somewhere low risk that's prudent, is better than making no interest. They got to do things like that. They're responsible for doing. That's the executor. They're responsible to make sure everything goes well, and the executor is accountable to the beneficiaries. So, like I said, at the very beginning when you asked about trusts versus a will, well, will creates a trust, and so the beneficiaries are the beneficial owners of the estate, and the executor is the one that's legally administering the estate, and often will hold the legal title to the property in the estate. So they're responsible for administering this trust for the beneficiaries who are the beneficial owners. And so they also have to report to the beneficiaries, here are the things that I did, and the beneficiaries can sue them if they screw up.
Wow. In a will, it's obvious that the estate should be taking care of any debts that the deceased has first. What happens if all they have are debts? Like, is the executor responsible for? If
the estate is bankrupt, then my advice to the would-be executor is don't bother taking it. So if someone names you as an executor, that doesn't legally bind you to be the executor.
Okay.
Like, you still accept to do it or not to do it.
Gotcha.
And I had somebody stop by for a consult the other day, and there was no will, and it looked like the estate was bankrupt. If not, there's maybe dollars, like a few dollars in it once everything is said and done. And they were very stressed out about, what do I do? How do I deal with this? And my advice to them was, don't do it. Why would you do it? Just walk away.
So you could literally just walk away from the duties of being an executor.
I've never, thankfully, I've never been bankrupt. I don't, but I know enough about the law and how that works to know that it seems like it's a fairly stressful experience. Why would you want to go through that as the executor for an estate that you're going to get nothing from?
Right.
Like what? So now your beneficiaries are like the creditors, the bank, the different financial institutions. So now you're responsible to them to make sure you're administering everything just right. Like that sounds like the last people I want to be working for.
No kidding. No kidding. Wow.
Yeah.
I mean, you've just brought to the surface a bunch of things. I'm sure it's probably bringing up a lot of questions for a lot of people. I have a feeling that there may be other subjects we can talk about, not in this conversation. I guess if somebody wanted to work with you, Evan, what would they need to do?
They could give us a call. They could send me an email. They could send our office an email. So our phone number is 780-571-8463. And they'll probably get Esther, who is our intake coordinator. She's also my wife. She's very nice, very easy to deal with, and very helpful. And she'll help you know what the next steps are. The way it works for estate planning is Esther will send you a questionnaire, which right now we use like a Google form. So it's pretty easy to fill out. You just go through, answer the questions to the best of your ability. And we get all the information about your financial situation, like all of it, because I need to be able to, we do it for two reasons. Number one, that helps me understand and make sure you're getting the advice that you need. And don't get me wrong, I've never given someone advice as to who they should be leaving what to. Like that, I couldn't care less. I have no interest in that. But it does, the extent of the estate, et cetera, and what you want to do with it may give rise to me giving advice about, for example, if you were going to leave everything to a charity, but meanwhile you have a spouse who's a stay-at-home mom and you aren't going to leave anything to her, obviously my advice would be, listen, you need to probably provide for that spouse. Otherwise she's going to have a claim against your estate and you're just making a mess. So we get all the financial information. And the second reason that we do that is because if there's any issues afterwards and somebody's suing the executor, the evidence of the person who prepared the will and their notes and everything they looked at is very important to help shed light on what were the real intentions of the person who made the will. So we get all this information, not because I'm going to put anything about your finances in the will, but because we need all those notes and background information. And then with that questionnaire, you also get a link to a video where I walk through the questionnaire and explain. And I also provide like tips about, executors, a little bit like of what we've talked about here today. So they get a little video where I explain that and how to fill it out and things of that nature, and some tips for things commonly people will do in a will to help you as you're filling it out. And when I review that information that you've filled out, either everything will look pretty straightforward, or it will look like, I think this person probably should have a conversation with me just to clear, or something's not clear to me or something like that. And so if that's the case, then we'll schedule a quick meeting where we'll have a little chat and I'll clear up anything I need to be cleared up or provide advice if there's something I think that you might want to know. And then I prepare the drafts. You get the drafts by email. You look them over. We send the drafts as well as like a link to schedule the signing meeting. So you review the drafts and then schedule your signing meeting. You come in and I got a big screen TV in my conference room to put the documents up there so everyone can see them and read them, no matter how bad their eyesight is. Even if your eyes are really good, it's a lot easier for us all to look at it on a TV than to like passing around paper. We go through it. We go through it line by line, explain everything, and it's still in a Word doc. So if there's any changes we need to make, I can make the changes right there. We print them out and sign them, and you walk away with your new wills.
Wow. Okay. I mean, it sounds like a little bit of work. Obviously, it should be because you're doing something rather important. But it's worth it. And it sounds like it's pretty easy to maybe even make amendments if you had to, I guess, if they kept dealing with the same lawyer.
Yeah, I mean, usually, honestly, what happens is when somebody needs to make changes, that we just do new wills. That's usually what we do, simply because my precedents are always, we're tweaking them here and there to make them better, right? When we find something, or if the law changes and we're updating them. And so usually people aren't making changes like within 6 months or something. Usually it's a few years later, and usually the precedents have changed since then. And so we'll just do new ones. But I mean, we try to make it as painless as possible for you. So really, from your perspective, what you need to do is, number one, fill out the questionnaire. Number two, read the drafts when they come to you. And then number three, show up to the signing meeting. That's it.
Yeah, that's true.
That's all you
Yeah.
got to do. I gave you all the background. Like, yes, we're doing stuff in the background. I gave you all the background. Like, yes, we're doing stuff in the background. Like, yes, we're doing stuff in the background. We're drafting them all. And if I might have questions, I'm looking at everything you send and I'm analyzing things and stuff like that. But from your perspective, you fill out the questionnaire and then the ball starts rolling and you just show up and we do all the work. You know what I mean? Like we try to make it as painless as possible for our estate planning clients.
Right. Gotcha.
Everyone dreads it. I don't know why they dread it, but like it's just like, I know I need to do this, but where do I even start? And so we try to make it, once they get the courage to start, we try to make it as just get the momentum going and get it done as quickly and as painlessly as possible.
Well, I think that's a very interesting question. Like, why do people dread it? I can see that as well. But I guess that's a different conversation. If you wanted to kind of leave a lasting, maybe statement or advice to my viewers, my clients, your viewers, what would you like to leave, Evan?
I guess, especially when it comes to estate planning and preparing a will, we charge $950 for a will, $300 if for the second set of will documents, the will and other documents, if we're doing mirror image ones for a spouse. And I recognize that's not like $50 that you can spend at Canada Post to buy a will kit or something like that. It's a chunk of money. But if you screw something up in your will that you did out of a will kit, or you just do it in your own handwriting, which we call a holographic will, like I mentioned at the beginning, and it's messy or unclear, and now people have to go and fight about it in court after you die, you didn't save any money, because guess who pays for the court fees for fighting about something that was unclear in the will? The estate does. It comes out of the estate. At least some of it will. So I would just say, like a lot of things, if you spend the money up front, now, given if you die, you die, and you're not worried about how you left all of the money. You couldn't take any of it. So, there's that kind of cynical perspective where you're just like, whatever, I'm dead. They can do whatever they're going to do. But if you are wanting to set things up and make it as easy as possible for your wishes to be fulfilled for what happens with your stuff when you die, then getting a lawyer, it doesn't have to be me, but getting a lawyer to do a will for you is going to be financially the better bet, the better investment than just trying to save a few dollars and doing it yourself or online or through a will kit.
Yeah, I agree with you. I can't agree with you more. That's awesome. Well, I appreciated you taking the time today, Evan. Thank you so much for sharing your information. And maybe one day we'll talk about something else. I hope everyone got value from this video. And please, I'll put the information in the description below about how to reach out to Evan, how to help, how to deal with wills, and maybe any other questions you might have for him. Thank you so much for watching. Got you all. Have an awesome day.